Welcome and thank you for taking the time to join us today. I'm Charlie Imbergamo, Director of Strategic Programs for the Nonprofit Leadership Center. We have a few of our NLC teammates with us today. So on behalf of all of us, we're delighted to have you with us as we continue our mission to develop and connect nonprofit leaders in this virtual space from far and wide. To recognize you and the organizations and communities you represent, we would ask that you find the chat box and please type the name of your organization and the location in the chat right now. And as we see your locations and organization names pop into the feed, we will celebrate you and additionally welcome you. We are delighted to be joined today by Scott Silverman from Ackerman, adept at navigating complex labor and employment matters. Scott is noted by Chambers USA for being expeditious and excellent at providing all points of view. His range of expertise includes representation of employers in administrative proceedings, federal and state court litigation, and arbitrations. Although he's worked on a variety of labor and employment issues throughout his career, Scott's practice has emphasized labor management relations, employment discrimination, non-compete trade secret, wage and hour and retaliation claims. Complementing his litigation practice, he advises employers on day-to-day matters and drafts manuals and contracts for his clients. Board certified by the Florida Bar in labor and employment law, Scott frequently lectures and publishes articles on current developments in labor and employment law. Today's topic is no exception. As we prepare to learn about Florida House Bill 7, the Individual Freedom Act, I'd like to take an opportunity to remind us that this law and others like it being contemplated around the country need to be understood in their scope and restrictions, and that NLC's purpose for bringing this topic forward is so that we can meet the burden of compliance alongside exercising our commitment to advance the work of diversity, equity, and inclusion, and seeing that that work might continue within the framework of this and any standing law, providing each of us with the resources that we need to act within the scope of the law while continuing our organizational plans for training and development in the areas of DE&I. Moderating our session today is my teammate, Karina Kletter, NLC's Program Associate. Karina has been an awesome driving force in our work and in making our platforms accessible for all participants. She's passionate about our work and committed to respond to the needs of our community in providing quality resources. Karina will take us through some rules of the road for our time together, and then we will pass it on to our trainer for today. Karina.
Thank you, Charlie. So I'll just go over a few of our rules of the road for today's webinar. To minimize background noise and distractions, all lines will be muted for the duration of the webinar. The session is being recorded and will be available on our website in the next few days. We will also share the slide deck when we post the recording. You may have noticed that we have live captions enabled, which is a Zoom accessibility feature. If you find them distracting, or if you would like to see them but don't see them yet, you can enable or disable them by going to the bottom of your Zoom screen and clicking on the icon that says CC Live Transcript. Once you click that, click the button that says Disable Auto Transcription or Enable Auto Transcription. We warmly welcome your questions. Please type them in the chat box as they come up for you, and we'll take 10 to 15 minutes at the end of the presentation for Scott to answer as many as we're able to get to. If you haven't found the chat box yet, go to the settings at the bottom of your Zoom screen and click on chat. And if you haven't already, please share the name of your organization in the chat box. We're so delighted to have Scott with us today and look forward to a great informative webinar. On to you, Scott.
So is everybody seeing that okay, Karina?
Looks great. Thank you, Scott.
Great. Thank you so much. I really appreciate you having me, and I look forward to this session with everyone. Today's session is what the Individual Freedom Act means for your nonprofit and diversity training. So the first thing we're going to discuss is the act itself. And then I'm going to talk about the recent federal court decision and what that means. And then, as Karina said, we will hopefully have time at the end of the presentation for questions. So going to the act itself, the act amends the Florida Civil Rights Act. Well, what is the Florida Civil Rights Act? The Florida Civil Rights Act secures for employees within the state of Florida freedom from discrimination because of race, color, religion, sex, pregnancy, national origin, age, handicap, or marital status. All of those characteristics are what we describe as protected classes under the Florida Civil Rights Act. What the Individual Freedom Act does is that it provides it is discrimination under the Florida Civil Rights Act based on race, color, sex, or national origin to subject an individual as a condition of employment to training, instruction, or any other required activity that espouses, promotes, advances, inculcates, or compels such individual to believe specified concepts, which we will get to. So you'll know that there are many different things that are required to violate the act. It has to be a condition of employment. There has to be required activity. There has to be one of the 4 or 5 verbs, and there has to be specified concepts. And we'll go through each of these factors as I go through the presentation. The Individual Freedom Act was nicknamed the Stop Woke Act by Governor DeSantis. Stop the wrongs to our kids and employees. It did go into effect on July 1st, 2022. And as I believe I mentioned, we will discuss the federal court order and joining the Individual Freedom Act at the end of my presentation. So let's talk about what are the prohibited concepts under the Individual Freedom Act. And I'm going to run through these with you. Number 1, members of one race, color, sex, or national origin are morally superior to members of another race, color, sex, or national origin. Number 2, and by the way, on number 1, the federal court, when I get to this, found that was vague. What number 1 means was vague because what is moral superiority? Number 2, an individual by virtue of his or her race, color, sex, or national origin is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Number 3, an individual's moral character or status as either privileged or oppressed is necessarily determined by his or her race, color, sex, or national origin. Number 4, members of one race, color, sex, or national origin cannot and should not attempt to treat others without respect to race, color, sex, or national origin. And on this number 4, as the federal court found, it had a triple negative, which made it completely vague and ambiguous as to what is meant by number 4. Also note that on number 3, what does necessarily determined mean? I mean, all of these things, as we will discuss, are very vague and ambiguous, and all of the language used in the bill is very important to make a determination as to whether there is a violation of the bill. So we've gotten through 4 of the prohibited concepts. There are 8, so we got 4 more to go. An individual by virtue of his or her race, color, sex, or national origin bears responsibility for and should be discriminated against or receive adverse treatment because of actions committed in the past by other members of the same race, color, sex, or national origin. Number 5, an individual by virtue of his, number 6, an individual by virtue of his or her race, color, sex, or national origin should be discriminated against or receive adverse treatment to achieve diversity, equity, or inclusion. Obviously, that would have impact on affirmative action type training. Number 7, an individual by virtue of his or her race, color, sex, or national origin bears personal responsibility for and must feel guilt, anguish, or other forms of psychological distress because of actions in which the individual played no part, committed in the past by other members of the same race, color, sex, or national origin. And the final prohibited concept under the Individual Freedom Act is such virtues as merit, excellence, hard work, fairness, neutrality, objectivity, and racial color blindness are in fact themselves racist or sexist, or were created by members of a particular race, color, sex, or national origin to oppress members of another race, color, sex, or national origin. So as you can see, the law as written is very expansive. And it covers as I said, eight concepts. Now there is an exception under the law. The Act does not prohibit discussion of these concepts as part of a course or training or instruction, provided that such training or instruction is given in an objective manner without endorsement of the concepts. And as we'll get to, the federal court found that this was vague and ambiguous because what is objective? What is endorsement? And what is allowed and what is not allowed under the exception the federal court found to be vague and ambiguous, which you can see by the language of the law. Again, objective is a loaded term, and what is endorsement? And we can talk about what the federal court found with respect to the exception. So again, that's the framework of the law. You know, there has to be this required training, instruction, or other activity that is a condition of employment, that one of the four verbs deals with one of the eight concepts that we've discussed. So what are the important points to know about the law as written? Again, I'm going to keep saying this because it's vitally important. The training, instruction, or other activity must be required as a condition of employment. So if it's voluntary, the law doesn't apply. So I'm having a trainer come in for lunch, all are invited to attend, but it's not required. And if you don't attend, there'll be no adverse action taken against you. That training falls outside of the law. That training can deal with any of the prohibited subjects. Why? Because it's not required as a condition of employment. So that's very important to understand. Then note the verbs. Promote. And I did a dictionary research on this. So promote means further the progress of a cause, support or actively encourage. Advance, to bring forward for acceptance. Inculcate, to teach and impress by frequent repetitions or admonitions. Compel, to cause to do or occur by overwhelming pressure. So the training itself, in addition to being required as a condition of employment, must do one of those four actions with respect to any of the eight concepts. Okay. And again, the restriction is to the eight concepts. So, and then I'll move on from this point. But again, I just want to make everyone in attendance understand there are the four requirements. Must be required as a condition of employment, one of the four verbs, and one of the eight concepts. Okay. So that's your prima facie establishment of a violation of the statute, those four elements. Okay. So as I mentioned, the law amends the Florida Civil Rights Act. The Florida Civil Rights Act only applies to an employer of 15 or more employees for each working day in each of 20 or more calendar weeks in the current or preceding calendar year, meaning from the time of the alleged unlawful conduct, and any agent of such a person. Now, what that language means, what it says is, and any agent of such a person, that merely provides that the company is liable for the actions of its agents. There is no individual liability under the Florida Civil Rights Act. So individual supervisors and managers, individual trainers cannot be held liable under this law. It's only the company itself, the employer itself, that can be held liable, not individuals. Okay, so again, it only applies to those employers with 15 or more employees. What does the FCRA provide? It provides that it's unlawful for an employer to discharge or otherwise discriminate against a person with respect to compensation, terms, conditions, or privileges of employment because of membership in a protected class. It also provides that it is unlawful for an employer to limit, segregate, or classify employees in any way which would deprive or tend to deprive a person of employment opportunities or adversely affect a person's status as an employee because of membership in a protected class. So what the Individual Freedom Act did is it established that if action is taken that violates the Individual Freedom Act, it falls within the Florida Civil Rights Act provisions that I just discussed, to the extent that the employer has 15 or more employees, of course, because anybody under 15 employees is not covered. But if you got a covered employer, if you violate the provisions of the Individual Freedom Act, it is made a violation of the Florida Civil Rights Act, and it would fall within these prescriptions that I've just discussed. So that's what the law does. Okay. So what would be the procedures? I think it's important to understand, okay, Scott, you've told us about what's required to violate the act, and you've told us that the violation of the act becomes a violation of the Florida Civil Rights Act. So what happens? There's a violation of the Florida Civil Rights Act by violating the Individual Freedom Act. What is the process? That's important to understand. Okay, a person aggrieved by the violation of the Florida Civil Rights Act through the Individual Freedom Act may file a complaint with the Florida Commission on Human Relations within 1 year of the alleged violation, naming the respondent, the responsible party, the company, and describing the violation. Within 25 days of that, the respondent, the company, has to answer that. And then the agency investigates the allegations and determines if there's reasonable cause to believe that a discriminatory practice occurred within 180 days. If the agency, the Florida Commission on Human Relations, determines that there is a reasonable cause within that 180-day period, the aggrieved person can bring a civil action or can request an administrative hearing within 35 days. If the agency determines that there is no cause to believe that there's been a violation, then only the administrative hearing is available. So again, you file a charge, determination is made. If it is caused, then the individual can either go to court or request an administrative hearing. If it's no cause, then the employee just has to go to an administrative hearing. If the employee chooses to go to a civil action, that has to be brought within 1 year of that reasonable cause determination or the final agency action. Here's what can happen if you're determined to violate the law. The court can award affirmative relief. That includes back pay, money lost, and either reinstatement or front pay. So if the employee's been fired, the court could order the employee reinstated, or the court could order that the employee get the employee's normal compensation for a length of time going forward that will allow the employee to become employed with another organization. Also, unlimited compensatory damages. So unlike the federal law, under the Florida law, there is no cap on compensatory damages. If a jury believes that the person suffered $1 million worth of emotional upset, that is allowed. However, unlike the federal law, there is a $100,000 cap on punitive damages. So an employee cannot get more than that for violation of the Individual Freedom Act. And of course, the employee could also get attorney's fees and costs. So the defendant would be ordered to award to the plaintiff all of the plaintiff's fees and costs in any sort of case. Note that compensatory and punitive damages are not available in an administrative hearing. So the trade-off there is you don't get compensatory and punitive damages, but you get to a result quicker. Most of the time, cases go into court for the ability to get compensatory and punitive damages. Next, if the Florida Commission on Human Relations does not make a determination within 180 days, then the person can proceed as if reasonable cause was determined. And so the commission has to do something within 180 days. If they don't, then the right is given to the person to either file a lawsuit within 1 year or to request an administrative hearing within 35 days. When the FCHR does not do anything, they give a notice to the individual, and that informs the individual of options and that a civil action must be brought within 1 year. So the FCHR is supposed to do that if they don't make a determination within 180 days. What's important to note here is that because these claims are not covered by Title VII, Title VII, the federal law, does not have the provisions of the Individual Freedom Act. So complaints under the Individual Freedom Act are solely dispositive under the Florida regime, and they're not subject to dual filing with the EEOC, which is the federal agency. Most of the time with other discrimination claims, they're only decided by the federal agency because of work sharing agreements between the EEOC and the FCHR. Here, it would solely be subject to the FCHR process, what I've just described. In addition to the FCHR process, the Florida Attorney General can bring civil actions against employers for damages, injunctive relief, and civil penalties of up to $10,000 per violation. But the Attorney General has to have cause to believe that the employer engaged in a pattern or practice of discrimination or otherwise engaged in discrimination that violates the Individual Freedom Act. So again, we have the two paths. One, the individual has to first file a claim with the Florida Commission on Human Relations, and then it goes through that process that I just described with the Florida Commission on Human Relations. Or the Florida Attorney General can bring civil actions against the employer on the Attorney General's own behalf, seeking all of the damages that are there. So those are the two ways that the Individual Freedom Act can be enforced. And as we'll get to the court order that was entered, the court enjoined the Florida Attorney General, Ashley Moody, from enforcing this law, and also enjoined the Florida Commission on Human Relations from enforcing the law. What the court did not do is, and I'll get to, is prohibit individuals from suing to enforce the law in court. That can still happen despite the federal court order, which we will discuss. Okay, so I've discussed what the law prohibits, how the law becomes a violation of the Florida Civil Rights Act, and what the process is for a violation of the Florida Civil Rights Act to be litigated. So we're now going to talk about some ideas for compliance with the law. And I'm going to go through these in some detail. Obviously, you need, as an organization, to review your EEO policies and procedures to ensure that your employee handbook and orientation materials do not transgress the prohibited concepts. That would be the first thing that you need to do to comply with the law. Next, you have to make sure that DEI training and programming that would be out of compliance with the law is optional. So make your DEI training and programming optional. Tell employees in writing that they may opt out, and have all employees sign their understanding that training is not required. At that point, as I explained earlier, the training is not subject to the Individual Freedom Act prescriptions because it's not mandatory. It's not a condition of employment. So that training or lecture can talk about anything. It could even deal with the prohibited concepts. But if you're going to do that, again, you need something in writing from the employees that it's optional and they understand that it's optional. Obviously, a process is to use professional DEI trainers. These companies are cognizant of the law and their training should be in line with the law. However, we do recommend that if using a professional DEI trainer, to review the material in advance, hopefully with a lawyer, to ensure that it complies with the law. This is, of course, if the training is required and mandatory. To avoid issues with discussions going into prohibited areas, consider pre-recorded presentations with no questions allowed and nothing that occurs in the meeting that is not by script. Obviously, if there's going to be things that are off script, there could be disputes as to whether any of the prohibited concepts were espoused or advanced. So therefore, it may be a good idea to just have pre-recorded presentations where you can effectively establish exactly what occurred in the training. Also, consider indemnification provisions if you use an outside trainer, whereby the trainers must identify the company for any liability. If the trainer is providing the service, the trainer is certifying that the training is in compliance, and the trainer would therefore agree to indemnify the company for any liability of the company as a consequence of the training. That is something to consider. Preserve all materials, recordings, and slides of any mandatory training to establish what was discussed and what were the topics, again, to show that the prohibited concepts were not part of that training. May also consider providing written disclaimers that the training does not endorse any of the prohibited concepts, and that the training is not intended for any individual to believe or support any of the prohibited concepts. This, of course, would establish that the act was not violated, because all the attendees are signing an acknowledgement that the prohibited concepts are not endorsed, and that the individuals attending the training are not being asked to believe or support any of the prohibited concepts. If you have that in writing and acknowledged, that would be very effective in defending any claims under the Individual Freedom Act. And the last suggestion on this topic is don't stop training. I know a lot of my clients said, well, we're just not going to do a training anymore. That risks loss of an affirmative defense. Some of you may be familiar with the Farragher-Ellis affirmative defense under federal law. What that legal concept says is that if an employer trains employees on harassment and equal employment opportunity, that the employer may effectively defend any claim of harassment by an employee against a supervisor or a co-employee. So if you don't do the training, then you would lose that affirmative defense to claims of harassment and discrimination under both federal and state law. If you do harassment or equal employment opportunity training, then the employer can defend that any harassment or discrimination occurred outside the scope of employment, and that the employer had taken effective measures to stop harassment and discrimination, and therefore should not be held liable for any harassment or discrimination that occurred. That is what is very important about doing training. So that is why you should not stop training because of this law. Training is very important and should continue, but you should consider whether to make sure that the training does not violate the requirements of the Individual Freedom Act. Okay. So I've alluded to a federal court order, and so I'm going to talk about that now. We've talked about the law. We talked about how a violation of the law is a violation of the Florida Civil Rights Act. We've talked about the process under the Florida Civil Rights Act when an individual believes that there's been a violation. And then I've talked about some suggestions on what employers can do in reaction to the Individual Freedom Act. As can be expected with a law like this, there was a legal challenge to the law. And that was in the case of honeyfund.com Inc. versus DeSantis. In this order, the judge was very, very critical of the Individual Freedom Act. The judge compared Florida to the Upside Down in Stranger Things. Those of you who have Netflix may be familiar with this show. Apparently, I don't watch the show myself, but I know from my sons that the show is about another world, which is the Upside Down, which is the opposite of what the reality should be. And so the judge compared Florida to the Upside Down and said, in Florida, public entities can restrict speech, but private entities cannot, which is the total difference of what it should be. The United States District Court for the Northern District of Florida granted a preliminary injunction to enjoin government officials from enforcing the IFA. what the court found was that the IFA is a naked viewpoint-based regulation on speech that does not pass strict scrutiny. And I'll get to what strict scrutiny means. But basically what the court was saying was it only targets certain speech with respect to the concepts. It only targets speech as to those 4 verbs that I talked about with respect to the concepts. So you can condemn the concepts as much as you want without violating the law, or you can take no position as to any of the concepts without violating the law, but it's only those who actually espouse any of the concepts that are in violation of the law, which, according to the court, was obviously a viewpoint-based regulation on speech. It was only targeting a certain viewpoint and not any other viewpoints on these concepts or these ideas. And so therefore the court found that because it was a viewpoint-based regulation on speech, that it was unconstitutional under the First Amendment. So let me give you some of the background about this case. So plaintiffs were employers who wished to mandate prohibited trainings and a diversity and inclusion consultant who provided such trainings. Defendants were Governor DeSantis, Attorney General Ashley Moody, and the commissioners of the Florida Commission on Human Relations. That's that agency that enforces the Florida Civil Rights Act that we discussed. For technical legal reasons, the court found that Governor DeSantis was not a proper party to the injunction. Okay, so Governor DeSantis was not enjoined by this court order. It was only Attorney General Moody and the commissioners of the FCHR. So what were the concepts that the plaintiffs in this case wanted to teach? The employers and the consultant wanted to provide training on advancing women in business, understanding gender expansiveness, understanding institutional racism, dominant group theory, racial bias theory, and white man's privilege and guilt theory, as well as systemic racism. So I've described the concepts to you during the presentation. And so you could see why, based on the topics that the plaintiffs wanted to discuss, that they had a fear that this would violate the law. We can see that. Obviously, white man's privilege and guilt would, as an example, could violate one of the concepts because it could require that a person feel guilt over actions taken by a member of his or her own protected class. So the court found that there was clearly standing by the employer and the consultant to challenge the law because they were in reasonable fear that they would violate the law by promoting these trainings. And so therefore they had to take actions to not conduct such trainings. And so they were being adversely affected by the law. And so they certainly had a right to challenge the law. So there's that background. Okay, so what did the court decide? First, the court found that the Individual Freedom Act regulates speech by only targeting required training, instruction, or other required activity that espouses, promotes, advances, inculcates, or compels such individual to believe the specified concepts. It only targeted that limited speech. It did not ban required training, instruction, or other activity that condemns those concepts or that takes no position on the concepts. So the court found it was a clear regulation of speech and not conduct. And the court found that by targeting the content of the required activity, the Individual Freedom Act does not only have an incidental burden on speech. Why? Because speech was the actual target of the law. It wasn't targeting conduct that has an incidental impact on speech. For instance, let's take Title VII. Title VII, of course, is targeted at conduct, discrimination, or harassment. So it's not a target on speech per se, it's a target on conduct that discriminates against a member of a protected class. Does it have an incidental burden on speech? Of course, because in the workplace, I am prohibited from making certain statements that are found to be unlawful. I can't make these statements in the workplace. but the law itself is not aimed at the statements. The law itself is aimed at conduct of an employer. So by prohibiting speech based on viewpoint, the Individual Freedom Act was not aimed at conduct with an incidental impact on speech. It was actually aimed at speech, and therefore it was subject to strict scrutiny. And I'll get to what that means in just a few minutes. So what did defendants argue in response? Well, they said, well, that's fine. If we have to pass strict scrutiny and we don't, then Title VII is unlawful, because Title VII also prohibits unlawful activity on the basis of a protected class, which is exactly what this law does, right? Because we talked about that earlier, where the law says that taking action, required action with regard to any of the concepts is discrimination. And so the plaintiff said, well, that means that the defendant said that, if this is unlawful, then all anti-discrimination laws are unlawful because this does the same thing. And the court rejected that out of hand. The court said that, as I explained in just a few minutes ago, that Title VII only targets conduct and incidentally burdens speech, whereas the Individual Freedom Act directly targets speech, as we saw from the language of the law, and it directly restricts speech and only incidentally burdens conduct. So that was the distinction. Again, Title VII and anti-discrimination laws are pointed at conduct and may have an incidental burden on speech. But by its language, the Individual Freedom Act directly targets and restricts certain speech and may only incidentally burden conduct, such as, incidentally burden the conduct of conducting a training. So the court's reasoning on that appears to be very sound. So what is strict scrutiny? So laws that constitute a viewpoint-based regulation on speech must be narrowly tailored to serve a compelling state interest. Okay, so you have to have two things. So the only way this law was going to pass would be if it met those two things. Narrowly tailored to serve a compelling state interest. The court held the state has no interest to censor speech it finds repugnant, no matter how captive the audience. In other words, the government can't decide for itself what is repugnant and what is not repugnant. I mean, the First Amendment guarantees, according to the court, everyone the chance to engage in speech, and the government can't censor speech based on how it views the speech. In addition, the court found that the act was not narrowly tailored because the Florida Civil Rights Act already prohibits discrimination and harassment. So it was not necessary and therefore was not narrowly tailored to serve an interest. For instance, mandatory training could be so offensive and hostile to white employees that it creates a hostile work environment that would be actionable already under the Florida Civil Rights Act. So what the act did, the Individual Freedom Act, was, quote, sweep up an enormous amount of protected speech to ban a sliver of offensive conduct. As I explained earlier, in addition to the First Amendment finding, the court found that the Individual Freedom Act was unconstitutionally vague. The court pointed to concepts 1 and 4 that we've discussed about, and also the qualifier, as I discussed, as being unconstitutionally vague. Again, those were the morally superior concept. That other concept was members of one race, color, sex, or national origin cannot and should not attempt to treat others without respect to race, color, sex, or national origin, which was a triple negative, which made it completely vague and ambiguous according to the court. And finally, the qualifier, talking about objective and without any endorsement. Again, the court found these terms to be vague and ambiguous when applied to real world circumstances. So what now? Okay, what now? We have this court order. So the decision is expected to be appealed to the 11th Circuit Court of Appeals, of course. And what that means is, a lower court has made its determination. There's now a higher court that can hear the case. And then that higher court could either agree or disagree. If the higher court disagrees, then the injunction is lifted. If the higher court agrees, the matter could eventually go up to the Supreme Court. But for the moment, the preliminary injunction halted any enforcement of the Individual Freedom Act against Florida employers by General Moody and the Florida Commission on Human Relations. What I want to make clear is it does not prevent private actions by individuals. That's because an employee who brings a charge will not get any FCHR action within 180 days. Why? Because the FCHR is enjoined from taking any action under the court order. So the employee is going to be able to go to court under the FCRA because the employee will not get any action within 180 days. And then the employee will have the right to file a lawsuit. Now, in that lawsuit, obviously, the court could agree with the court in this case. And the court could find, well, the law is unconstitutional, and therefore you don't have a claim. But again, there is no injunction for individuals to enforce this law. So today, if an employer in Florida today violates the law, that employer is subject to lawsuit by the individual despite this court order. So employers should continue to review employee training and other diversity measures. I also want to make up the point that let's put aside the Individual Freedom Act, put it aside. All that does is it creates a statutory presumption that the topics constitute discrimination on the basis of a protected category. An employee could still argue that any of that training that it violates the Individual Freedom Act is a violation of the Florida Civil Rights Act. And therefore, the employee could still argue that any of this training that the Individual Freedom Act prohibits is already covered by the Florida Civil Rights Act, and could bring a claim directly under the Florida Civil Rights Act. And the employee could argue that the FCRA should be interpreted to allow the cause of action by someone who is adversely impacted by such training, regardless of whether the Individual Freedom Act applies or not. So there are two, and then I'll be able to get the questions now. But there are two ways, again, that the Individual Freedom Act could still apply. One, individuals can directly pursue a legal claim under the act in court. And two, individuals can use the Individual Freedom Act to argue that the Florida Civil Rights Act already prohibits this type of activity, and therefore I can bring a claim directly under the Florida Civil Rights Act. So for both of those reasons, it would be important for employers to continue to analyze and review their training and other diversity measures to make sure that the act is being complied with, or to at least make a decision as to what training and equity inclusion seminars the employer should provide. And I think we are now able to take any questions. I've gone through my deck.
Okay, thank you so much, Scott. That was a very informative presentation. I do have a few questions that came in through the chat, and I also have a question that we got when we were taking registration. So I will start with the question that we got when somebody was registering. So the question is, does this act apply to our nonprofit training a group of community members or volunteers in these topics? And what if the volunteers were part of a Board of County Commission appointed group?
Right. So as I explained, the law only targets employers. So if the individuals whom we are discussing in the question are not employees, then the law does not apply. So it would not apply to mere volunteers of an organization. So at that point, if they are, if they're not employees, I think the question was if they are commissioners or they're volunteers of commissioners, then the law would not have any application.
Okay, thank you, Scott. So next question we have is from Jerry, and the question is, what is the difference between race and color in this law?
In the law, well, race includes your ethnicity. Color is simply the color of your skin. So under the Florida Civil Rights Act, for instance, you could have a white Hispanic, a lighter skinned Hispanic. So the race of that person is Hispanic, but the color is white. So that's the difference between race and color.
Great, thank you.
You can have discrimination based on either Normally they go together, but you certainly have, there have been cases where you have a distinction made between somebody's race and someone's color.
Okay, next question, also from Jerry. So the question is, so does the federal court halt this law until the vagueness and ambiguity is clarified, or is the law in effect with its vagueness and ambiguity?
Good question. So what the court order does is it enjoins those government officials, Attorney General Ashley Moody and the Florida Commission on Human Relations commissioners, from enforcing the law as it is currently written. The court had no ability, of course, to rewrite the law for the Florida legislature. So Florida could, if it wished, draft a new law to try and cure any of the vagueness or ambiguity questions that were raised by the court as to the 14th Amendment. I don't see any way really that the Florida legislature could avoid the First Amendment issue. So let me explain that again. There are two issues with the law that were decided by the federal court: First Amendment and 14th Amendment. The First Amendment is the viewpoint restriction on speech. And that was unlawful because it was directed at only certain speech, and it was not necessary to serve a compelling state interest. So it failed under First Amendment. The other was the 14th Amendment, which prohibits government regulation that is vague and ambiguous. And then the court identified certain aspects of the law that were vague and ambiguous. Would it be possible for the legislature to try to correct the vagueness and ambiguity? Perhaps. I don't see any way, again, that the legislature could correct the First Amendment concern with the law, because the law exists to prescribe viewpoint-based speech. So there'd be no way for that. To directly answer the question, the law is still on the books and it still exists. It's still a valid law, but the government officials, Ashley Moody and the commissioners, are not allowed to enforce it.
Okay, thank you, Scott. So we've got another few questions. We have about 13 minutes left. So if you have more questions, please add them to the chat. So this question, Scott, comes from Linda. And the question is, so does this mean agencies can no longer require cultural diversity training or DEI training / policies? No, absolutely not. Agencies can only require training that violates the law. In other words, that espouses, promotes any of the 4 verbs, any of the 8 concepts. DEI training that does not violate the terms of the law is perfectly fine. And again, the training has to be required as a condition of employment. So if it's just optional training, then it's completely lawful. Now, obviously you could have arguments about that in a case, right? The company says, well, it was optional. And the employee says, yeah, they say it was optional, but my supervisor went to me and they said, I better be at that training or I would regret it. So, that could always be litigated. Was it really optional or was it mandatory? Assuming that it is really optional in practice, then it falls outside the law. Even required training that doesn't violate the terms of the law, meaning the 4 verbs with the 8 concepts, is okay. So again, the law does not prescribe all DEI training at all. Okay, thank you, Scott. Yep. So next question, I think you may have spoken a little bit to this in another answer. The question is from Jerry, and how is the IFA constitutional if it targets and restricts speech? Well, that's what the court held, that it's not. The federal court held that it was unconstitutional under the First Amendment and also under the 14th Amendment for vagueness and ambiguity, and therefore that's why the court restricted those government officials from enforcing the law. So looking at the reasoning of the court, it doesn't pass constitutional muster and is unlawful under the court's decision. Again, it's subject to appeal. The 11th Circuit could view it differently. The 11th Circuit could possibly agree with the counter arguments made by the defendants in the case, that it only regulates conduct, or
It only has an incidental burden on speech. So, I mean, there are counter arguments that were made, but the court did find that it was unconstitutional under the First Amendment and the 14th Amendment.
Okay, so we've got a couple more questions.
Sure.
From Jerry. Jerry was paying close attention. Thank you, Jerry. So the question is, so if there's no lifting of the enjoinment ever, what do Moody and or FCHR do to lift the enjoinment?
Well, they would have to appeal the district court decision to the 11th Circuit and eventually up to the Supreme Court. Once there is a final federal court decision, then that's binding. So the injunction would then, the preliminary injunction would remain in place, and then the court could enter a permanent injunction prohibiting the state actors from ever enforcing the law. And so then that would just be a permanent injunction, and the law could never be enforced by the Attorney General or the Florida Commission on Human Relations. That does not mean, again, that individuals, as I explained, could not seek to enforce the law by individual discrimination suits or individual discrimination charges. That would be up for a court in those cases to make a determination as to whether the law is constitutional in those circumstances. Obviously, once that decision's been made, that would be precedent, and then that whatever decision was made in the first test case, if you will, that would be binding. And so that would probably set the stage for whether there could or could not be individual suits at that point. So that's to be seen.
Thank you, Scott. We have a couple more questions. One is, if there is no enforcement, why would any employer comply?
As I said, there can still be individual lawsuits. So it's not that there's no enforcement. It's that the Attorney General is prohibited from enforcing it, meaning the Attorney General cannot bring a case to enforce the law. And the commissioners are prohibited from enforcing the law, meaning the Florida Commission on Human Relations cannot issue any determination that the law has been violated, cannot seek to require employers to comply with the law, cannot administratively enforce the law at all. The court order does not strike down the law and erase it from the books, if you will. The law still exists. So individuals who claim to have been harmed by the law can bring a charge and eventually a lawsuit. Again, under the Florida Civil Rights Act, individuals have to first go to the Florida Commission on Human Relations to file a charge. There's no way to go directly into court. But as I believe I explained, when the individual files a charge, the FCHR, as of now, will be prohibited from taking any action on the charge. So at that point, 180 days will pass. No action will have been taken by the FCHR, and the individual will have a clear path to file a lawsuit to enforce the act. And then at that point, once the individual files a lawsuit, then the court in that case would make a determination as to whether the law is constitutional and can be enforced. So for that reason, the employer should comply with the law if they deem it expedient. That's, at some point it's a business decision.
Thank you, Scott.
Knowing the legal risk, it's a business decision.
So we have two more questions and we have about 5 minutes left. So these might be the last two. If anybody else has any last questions, add them to the chat and we'll see if we can get to them. The first is from Jacqueline. Jacqueline asks, is it true that cultural diversity training can be required as long as it doesn't violate the 8 concepts once a person is already an employee?
Absolutely. That's a very good summary. Yes, that is true. Required training is absolutely permissible as long as it does not violate the 8 concepts under the law. So you can have required DI training, you can have the required discrimination training, required harassment training, and as I explained, there's good reasons to continue the training.
Great, thank you. Last question we have is from Molly, and Molly asks, what would you recommend as some safe topics or concepts to teach?
Anything that's not prohibited. Here's what I would do, being serious. you want to teach your anti-discrimination policy. Nothing about an anti-discrimination policy is going to violate this law, right? You want to teach your anti-harassment policy. Nothing about an anti-harassment policy is going to violate this law. You want to teach your policies and procedures for reporting discrimination and harassment in the workplace. Nothing about that is going to violate this law. So if you just keep it into the general area of anti-discrimination, anti-harassment, equal employment opportunity reporting, those types of concepts are fair game, and they will not get you in trouble. I think once you start getting into concepts of affirmative action, you get into concepts of critical race theory, any of these types of concepts, then you might have an issue under the law. But if you keep it within your handbook, your policy manual, and your harassment and discrimination procedures, then you'd be fine. But again, anything that's not prohibited is fine, is good. So as long as, again, it doesn't fall within the 8 concepts, one of the 4 verbs with one of the 8 concepts, then it's okay.
Great. So that was our last question. I want to give a big thank you to Scott Silverman for sharing this incredibly informative and timely and thoughtful presentation. Thank you to everyone that joined us today. We'll be sharing the recording and the slide deck within the next few days. Please reach out to us if you have any questions, and keep your eyes out for upcoming webinars. Any final words, Scott, before we release our audience?
No, I just want to appreciate everyone's time. It was a pleasure, and thank you for having me.
Thank you again, Scott. Have a good afternoon, everybody.